an evolution of select emergency outpatient departments to a collaborative assessment room for emergency, or better known as the CARE model. Although he complimented St. Anne's by saying it was a well-run facility that is meeting the needs of the community, he goes on to recommend that it be moved to a CARE model, which would clearly mean a reduction in emergency room hours at that facility. Mr. Speaker, having a 24-hour, 7-day-a-week emergency room has been essential to the primary care of our residents in Richmond County, as well as an important recruitment tool for physicians. In fact, Mr. Speaker, you will note that the emergency room at St. Anne's has been closed for less than 10 days in the last 15 years. Again, Mr. Speaker, a perfect example of effective rural healthcare delivery in Nova Scotia. So my question to the Minister of Health, since she knows that St. Anne's is the only health facility that operates independently of any district health authority, will the Minister of Health advise what impact the Ross report will have on the operations of this facility?
The Honourable Minister of Health.
Thank you very much, Mr. Speaker. And again, I want to say to the honourable member, part of my visit to that facility will be to learn firsthand, to talk more to the staff and to residents of the community with respect to what their aspirations and needs are for their health centre. And I want to say to the honourable member that to reassure you that there is no objective to reduce hours at the St. Anne's Community Centre, Mr. Speaker. What we probably will be looking at is a change or some difference in the mix of providers. So that all of the burden isn't placed on one physician to be available all the time. So we're looking at collaborative models, we're looking at the right mix of staff and facilities, and we're looking at being absolutely certain that communities have good primary care and good emergency care, particularly during those hours when those things are required, Mr. Speaker.
The Honourable Member for Richmond on your final supplementary.
It's with the mixed feelings I react to the Minister's response, because while Dr. Ross looked at other facilities where there's been chronic closures, where patients are not able to see their family doctor in a timely fashion because of their need to keep the emergency rooms open, the Minister should probably be aware, through Dr. Ross, that that's not the situation at Ilmadam. St. Anne's was closed 10 days in 15 years. It's working, it's not broken, and it doesn't need to be fixed. That is the message that was sent directly to Dr. Ross. It's the same message that will be given directly to the Minister of Health. Why there continues to be the suggestion that something needs to be changed at a facility that is functioning, that the local physician is quite pleased with how it's functioning, and that's been able to attract other physicians to come to the area, is a confusing message being sent to the residents of Ilmadam. Again, because of the fact that St. Anne's doesn't fall under any district health authority, it will take a decision directly from the Minister of Health as to what its future is going to be. So again, my final supplementary, will the Minister today assure the residents of Ilmadam and surrounding area that there will be no reduction in emergency care services at St. Anne's Centre?
The Honourable Minister of Health.
Thank you very much, Mr. Speaker. Mr. Speaker, I think it's important to state that the visit I intend to make to this centre, and indeed to other centres, is to be looking at ways that we can enhance and improve healthcare services, not take away healthcare services, Mr. Speaker. And the other thing I would say to the honourable member, we remember, I'm sure, the Corpus Sanchez report that recommended that community health facility be brought into a DHA, and I want to say to the honourable member that that's not a direction that this minister is going to go in.
The Honourable Member for Argyll.
Thank you very much, Mr. Speaker. My question is for the Minister responsible for the Emergency Management Office. On Friday, November 5th, as you know, it started to rain, and it didn't stop raining for about 2 days. An unprecedented 240 millimeters of rain fell in the Yarmouth County area. This put many roads, culverts, bridges underwater. And by November 8th, we had a full-blown disaster on hand with a state of emergency called in the county and the evacuation of some communities, including Quinnen. Thankfully, the waters receded and those residents were allowed back in their homes. Mr. Speaker, could the Minister of EMO give us a quick update on what the next steps are for disaster assistance?
The Honourable Minister for the Emergency Management Office.
Thank you very much, Mr. Speaker, and thank you very much for the question. Before I begin to answer the question, I just would like to take the opportunity to recognize the hard work that was done in that area during this disaster. I was in constant communication with the MLAs for the district, who I have to say did an absolutely excellent job for their constituents. But I also want to acknowledge Warden D'Entremont and Warden Anthony, who were on the ground the whole time, making sure the citizens were safe. Now, what has happened now, we've now, thank goodness the waters have receded, and we are now assessing damage. TIR, the engineers, have been called in from across the province, and they're looking at 100 different structures. We are still in the process of assessing the damage. When we get a number figure associated with what we need to ask for, we will be entering into an agreement. As soon as we enter in that agreement, I will be letting members of the House know that. Now, I just want to explain a little bit about the Disaster Assistance Relief Program. When we enter into that, the citizens would be able to be reimbursed for their damages through the province, and we will capture that money later from the federal government. But I would say that after we enter in that, it would be approximately 6 to 8 weeks that citizens would be able to be reimbursed for their damages.
Thank you. The Honourable Member for Argyll on your first supplementary.
Thank you very much, Mr. Speaker, and I thank the Minister for her answer on that. Mr. Speaker, the Premier said in his press conference at the Argyll Municipal Office on November 10th about the disaster, and my quote is, his quote was this: "To say that it is incomprehensible may actually be an understatement." He also said that during the press conference that not opening or rebuilding bridges isn't an option he's pondering. Local residents are counting on him and keeping that commitment. So, Mr. Speaker, my question really is to the Minister of TIR on this one. Can you tell the House today what are the timelines for the replacement of the bridges on the Rennerton Road, the Saunders Road, and of course the one that collapsed in Tuscan?
The Honourable Minister of Transportation and Infrastructure Renewal.
Trying to cover your off there.
Thank you, Mr. Speaker. Thank you, Mr. Speaker, and thank you to the member opposite. I also must compliment you personally in your cooperation you've had with me as the Minister. The Tuscan Bridge tender has been called. It's going to take in the period of 2 to 3 months. There will be a new bridge there as soon as possible. It will be a 2-lane Delta panel bridge because of the importance that we will no longer have to be dealing with the pier that caused part of the problem. I know there's some other specifics, and I'm going to be running out of time, if I may. The other bridges, well, I can bring you the specific information later on, but I want to assure the people of your community that they are not forgotten. Those bridges are an integral part of the infrastructure of your community, and everything will be done as soon as possible. The Tuscan Bridge is one, but those other bridges will be addressed in a timely manner. Thank you.
The Honourable Member for Argyll on your first supplementary.
Thank you very much, Mr. Speaker. And as you know, that people are facing thousands of dollars of damage to fix, replace, damage caused by the flood. That damage is not covered by insurance. So people like Billy, Kevin, Randy Doucette are facing the cost of replacing furnaces and other equipment.
Order. The time for oral question period has expired. I'll now recognize the Honourable Government House Leader.
Conflict of interest. Good. Oh. Yeah.
The Honourable Member for Argyll on point of order.
Thank you very much, Mr. Speaker. Had such a great answer. I was just sort of caught off guard there. The Minister of Economic Development has been quoted job numbers, stats, and assumptions. Further to the request by the member for Cape Breton West, I would ask that you ensure the information is tabled, preferably by the end of work tomorrow.
Okay, it's not a point of order, but it's a reasonable request. The Honourable Government House Leader.
As long as we're not compelled, Mr. Speaker, because it's okay, Mr. Speaker. Bills for second reading.
Public bills for second reading.
Bill 99, the Conflict of Interest Act.
Bill 99, the Conflict of Interest Act. The Honourable Deputy Premier.
Thank you, Mr. Speaker. Mr. Speaker, I'm rising today to move second reading of an act to avoid conflict of interest by members of the House of Assembly, members of the Executive Council, public employees. Going forward, I will refer to it as the Conflict of Interest Act. Speaker, we are keeping our promise to make government more open and accountable to all Nova Scotians. We started by introducing new regulations for MLA expenses. We also promised to introduce standalone legislation to clearly define the rules around conflict of interest and disclosure for government officials. As proposed, this act will replace sections of the Members and Public Employees Disclosure Act of 1991. The act will strengthen and build on existing legislation. It will provide Nova Scotians with more accountability, a greater transparency in the future from members of the House of Assembly, members of the Executive Council, indeed, all public employees. We looked at existing legislation, Speaker, in other jurisdictions. Then we took the best provisions from each province and created an act that puts us more in line with the rest of Canada. In fact, Speaker, this act takes us from having a relatively weak conflict of interest legislation to having one of the strongest. This act, Mr. Speaker, will make MLAs, cabinet ministers, and public employees even more accountable to Nova Scotians. It will ensure that there are clear rules and guidelines around how to separate private interests from the interests of government. And it will give clearer instructions about what it is considered to be a conflict while a member is in office and for up to 1 year after leaving their position. The highlights of this new act include the Conflict of Interest Commissioner will post disclosure statements for every member of the House on a public website. We will be the only Atlantic province to do this. Members will have to disclose assets and debts of over $1,000. This will be changed from $25,000 in the previous act, Mr. Speaker. $10,000. $10,000. Members must also disclose the names of those who owe a debt to them in the amount greater than $10,000. This has also changed from $25,000 in the previous act. The same conflict of interest rules for ministers will also apply to ministerial assistants. Speaker, with this new legislation, the Conflict of Interest Commissioner will have additional authority to educate members, and public employees on their duties and obligations under the Act. He will also provide general advice and recommendations. Mr. Speaker, with those few words, I will take my place, but before I say it, I want to say also publicly that we have shared the regulations with the opposition party. Thank you, Mr. Speaker.
Thank you, Minister. I assume you had you called for second reading. You ordered it. Okay, I just didn't hear it. Okay, the Honourable Leader of the Official Opposition.
Mr. Speaker, Mr. Speaker, I want to thank the Deputy Premier for sharing what he called the regulations. They are the forms that members are to fill out that we already had. So I don't know. There's still some concerns. Well, we share the Deputy Premier and the government's wish to be more accountable, more open, more transparent, making sure that the conflict of interest legislation is updated, ensuring that Nova Scotians have greater trust in the work that we are doing here. Mr. Speaker, but there are some issues, as he alluded to. There's one jurisdiction actually in our country that posts things online. He talked about separating personal and private and public life. Mr. Speaker, as the member knows, the 52 of us have entered into public life. This legislation, though, goes beyond us. It takes into account and we want to make sure of that. I see the Deputy Premier shaking his head. We want to make sure of that, that's not only it does not include or put our spouses and our children in an uncompromising situation, Mr. Speaker. When I want to know, when I want to I'm wanting to know if as I was listening to the Premier, I wanted to know if I have to declare my 2 children who I think are indebted to me, or St. Mary's University and some other place which might be indebted to me more than $10,000. Mr. Speaker, but there are some concerns around that. I think we can go forward. There are some issues around posting. It's one thing, as you know, our caucus has been very vocal about making sure that how we spend public money should be posted online in a timely manner, that Nova Scotians get an opportunity to see how their member is spending public money. We're now talking about posting online how individual members spend their own private money. And you know, we need to see those regulations, how it pertains to that, to make sure that it is appropriate, that the interests of our families are being protected. Quite honestly, Mr. Speaker, and the fact that these new regulations do not deter people from wanting to seek public life because they're afraid of their personal finances being displayed on the internet. It's one thing when you disclose something to the Conflict of Interest Commissioner. It's quite another when you decide to post it on the internet for all to see. So we're going to continue, and I know that the conversation is going on, and we'll continue to ask questions from the Deputy Premier to clarify some of the questions that we have about that. And as well as a caucus, we have talked an awful lot about a code of ethics, one that we believe should be part of this legislation. It's a code of, it's really, Mr. Speaker, an opportunity for us as a house, as elected members, to begin to help continue to restore the trust of the people of this province when it comes to how we operate and how we conduct ourselves in our businesses. Mr. Speaker, as you well know, every other organization in this province practically has a code of ethics. The media have one. Mr. Speaker, if you go on the Home Builders website, one of the first things that pops up is a code of ethics. It's, Mr. Speaker, it's an inspirational code that all members of that organization aspire to, and that's what I believe should be part of this legislation for us. We've made recommendations to the Deputy Premier on how we believe they can be added to this bill. We will also be making a submission to law amendments about the clauses that we'd like to see added in terms of a code of ethics. I know that the Deputy Premier is very receptive of that good idea, and I know if he can convince his colleagues to join him. But Mr. Speaker, this is the beginning of the conversation that I believe we'll have over the next few days, and we come into law amendments. But we as a caucus certainly will make a recommendation, and we'll make amendments in terms around a code of ethics. And then there's some issues around making sure that what is being posted online pertains to members, making sure that we are protecting the interests of our families, quite frankly, and making sure that this legislation will not deter people from running for public life. Mr. Speaker, with those few comments, I'll take my seat.
Thank you. Chair now recognizes the Honourable Leader of the Progressive Conservative Party.
Thank you, Mr. Speaker. Mr. Speaker, this bill is a very important bill because ensuring public confidence in this House, in the officers of the House, in the members, in the ministers, and in ministerial assistants, in public officials is a very, very important objective that we all have a duty to ensure is achieved. Unfortunately, as all members know, we are often faced with a wave of public cynicism about our chosen profession, those that are the members of this House. A healthy dose of skepticism that it is important that we rise to deal with. My fear, Mr. Speaker, although this is a step in the right direction, my fear is that it won't satisfy those that want us to achieve that higher standard of public confidence. In fact, I'm not sure who the government consulted with as it prepared this bill and the accompanying regulations, Mr. Speaker. One would wonder if the general public, for example, were involved some way in the drafting of the bill, or some committee of the public. It's odd because this is a government that loves to consult on many other matters, that spends months and years in developing so-called strategies, that it defends its plotting ways by indicating that it's going through a period of public consultation or town halls or province-wide tours, and yet There is no evidence that that occurred on a bill as important as this, Mr. Speaker, and I find that odd because it is the public's view of conduct that we should be mindful of as we look at a bill like this one, Mr. Speaker, and it appears that the government has not done that. In fact, as I look through the provisions of the bill, although it is a step in the right direction, one can't help but think that the government has chosen to deal with a tidal wave of a problem with a thimble of a solution, a freight train of a problem with a pea shooter of a solution, Mr. Speaker. When you look at some of the specific provisions, such as lowering the threshold for the declaration of assets or debts from $25,000 to $10,000, I'm not sure that that will provide much greater comfort to the people of our province in their elected officials. Posting of the disclosure statements on a public website is a step in the right direction. The fact that we'll be the first in Atlantic Canada to do so is not really a high enough standard, Mr. Speaker, as it is accepted practice in many other jurisdictions long before now. Many of the other activities of members and ministers and assistants that the bill lists are obvious restrictions. That is how any Nova Scotian outside of this House would look at the restrictions that are listed. Mr. Speaker, I fear that when Nova Scotians get their opportunity to pass judgment on this bill, that they will find that it falls short of their objectives for conduct of public officers. Mr. Speaker, it's oddly light in many areas on the conduct of ministers and members and so on, but one area where it is bizarrely intrusive is on private citizens who have private interests, who have no connection to this House other than that they're married to a member or that they're a child of a member. And I think that we should think long and hard about that intrusion, Mr. Speaker. They are entitled to certain privacy rights in this country. They have not put their name forward for public office. They are entitled to a career of their own, to investments of their own, and so on, Mr. Speaker. And so I hope the government has weighed its decision to delve deeply and publicly into the financial and business affairs of people who are not members of this House, who are only connected by virtue of family to this House, and weighed that decision against the privacy rights and the right to pursue their own independent career that those individuals have, Mr. Speaker. And when we get to the next stage in this bill, when we get through second reading and get on to law amendments, we will be certainly looking at ways to improve that provision of the bill, to make sure that the objectives of greater public accountability are weighed fairly against the lives that spouses and children deserve to live by virtue of being a citizen of our country. Mr. Speaker, not only did the government not appear to take into account the desires of the citizens of the province in designing this bill, but it certainly didn't look very far for other models of accountability that it could have followed that have been tried and passed and tested. For example, the Federal Accountability Act, Bill number 1 of the current federal government, is a model that has become a model for our country and is a model that other legislatures have designed their own conflict of interest acts around. This government has chosen not to follow that example, and in fact, in many areas of the bill, it falls far short of the standards set by the Accountability Act of Canada, Mr. Speaker, and one can only wonder why. But that is only one place that we can look to set a new, higher standard, Mr. Speaker. That is the sphere of government. But as many Nova Scotians know from their own jobs, from their own employment, from their own employers, there are examples in the private sector of businesses and charities, other organizations that hold public assets in trust or set policy in trust, where they have designed their own version of this bill. But they have added to it, Mr. Speaker, with important additions to make sure they are always on the high road. Additions like a code of ethics, which, to be fair, both parties on this side of the House have been pushing for some time. Or a code of professional conduct, a very a very important and standard tool for many businesses and other organizations. We don't see that coming forward with this bill from this government, Mr. Speaker. Or something that I can speak to with personal experience from the credit union system, a statement of acceptable business practices. Each of these documents, call them what you will, are a step beyond this bill that are employed every day by everyday Nova Scotia businesses that all Nova Scotians have to ascribe to and sign on to. Often they have to sign them, affix their signature to these kinds of documents annually to make sure that they are aware of the provisions of the documents, of the conduct that is expected of them. They are trained and provided refresher courses and what is expected of them. And Mr. Speaker, they're also subject to severe penalties, including dismissal, when they're found to be in contravention of those types of statements in the private sector. The government has not looked to any of those examples before setting its own low, albeit better, but still low standard for this bill. In fact, the document speaks of penalties for members and others that are found in contravention of the Act, that a fine shall be no more than $10,000, Mr. Speaker. That is something that should be taken into consideration when we look at this in law amendments. One can only wonder, Mr. Speaker, what would happen if the bill had considered remedies to the public for a government that breaks its promises to the people at election time. I understand why that bunch did not want to go there, Mr. Speaker, but it is a valid question. It is something that people employed in other places have to consider every day. The bill is silent on a breach of trust, for example, Mr. Speaker, a very common concept in every other endeavor of employment. Having said that, Mr. Speaker, it is important that we take a step forward, even if the government is only proposing a baby step in the direction of greater disclosure, greater accountability, a higher standard of conduct for members and ministers and so on. And so we are prepared at this stage to support the bill, as minute as it is, on that basis. It certainly needs more work. There are lots of improvements. I've listed a few. I know the other party has listed a few as well. Hopefully the government is open to making the bill stronger, because we all have a duty to make sure that we do everything we can to enhance public confidence in our system of government, in this very House of Assembly. There are lots of important challenges that lie ahead for our province. This is the body where those issues are meant to be addressed. But we can only move forward and face those challenges and the opportunities that lie ahead for our province if the public has a high degree of confidence in this institution. The bill is a baby step in that direction. There are much more important steps along the way to get us to where we need to be in terms of public confidence so we can address those issues. I really do wish that the government had brought forward a much more comprehensive package of reform in this area. This is something that any panel of citizens would have told the government it needs to do towards that greater objective of public confidence. But they've chosen not to do this, so we'll take the baby step along with them and do everything we can on subsequent stages of the bill to make it better for all Nova Scotians. Thank you very much.
Thank you. The chair now recognizes the honourable member for Richmond.
Thank you, Speaker. I rise tonight to make some comments in regards to Bill 99, the Conflict of Interest Act. Mr. Speaker, I've had the opportunity since this legislation was first proposed to review it, and I found it interesting when the government House Leader indicated that the regulations had been provided to us as well. I was anticipating the regulations only to find that they are in essence the forms that we are expected to complete as part of our disclosure, and did not really deal with any of the other sections of the Act. Allow me to state right off the start, Mr. Speaker, very clearly, the changes being proposed in Bill 99, for me personally, have zero impact. I will not have to file an amended statement. There is not information or assets or debts that I have that weren't previously required to be disclosed that I will now be forced to disclose. It has zero impact on me. I would suggest to you, Mr. Speaker, that's going to have zero impact on almost all 52 members of this House. That's the reality. So when the government says that it's strengthening this and this is going to make big changes and everything, it really isn't. Let's be honest. So at a time when the government has moved, for example, in the small claims court's jurisdiction, has moved it up now to over $20,000, government turns around and says, well, now rather than having to disclose any assets or liabilities of $25,000, you have to disclose anything at $10,000. Again, for me, makes no difference at all. When I was first elected, Mr. Speaker, at the age of 25, I used to take great pride in pointing that my big liability was my student loan, and assets were none. And actually, when I was Minister of Environment, that was again what my disclosure statement said. My liability was a student loan. And that went on for quite a few years. And if I'm not mistaken, there may be a few members in the House right now that would be their liability as well. So let's be realistic, Mr. Speaker, of the members that are here in this chamber. So the changes being proposed, it sounds great when the Deputy Premier says it, but in reality, what real impact is it going to have? Right now, Mr. Speaker, as you're well aware, upon being elected, you're required to fill out a disclosure form. Not one, but two. The first one is called a member's disclosure form, where you're expected to give information such as your home address, your home phone number, and you're expected to list who your spouse is and who are your dependent children. Then you're presented with a second form, which is a form that you're to fill out on behalf of your spouse, where you're to disclose any assets or liabilities of your spouse and table that, present that to the Conflict of Interest Commissioner. My understanding is, right now the practice is that those forms are available at the Legislative Library, which is just outside of this chamber. But the practice has been that the Conflict of Interest Commissioner only makes available the first form, which is the one the member fills out, not the one that the member fills out on behalf of their spouse. What is being proposed today is to take both of those forms and post them online. Mr. Speaker, if we've learned anything in what happened during the expense scandal, is the baseless, rude, uncomplimentary, and damaging comments that people will make regarding the members of this House of Assembly with hidden names on sites such as the Chronicle Herald, CBC, and other sites. The thought that we would take personal information of members, of their spouses, of dependent children, and to put that on the internet to let these same types of individuals do as they wish with that information, such as your home phone number, your home address, knowing that many of us, like you, Mr. Speaker, who have to leave home and leave our spouses behind and our children behind while we're up here doing our work, that information of where they live and what their home phone number is will be available online for anyone to use as they wish, more importantly, for anyone to abuse as they wish. When I first raised that concern, the answer that came back to me was all sorts of Canadian jurisdictions have moved towards this practice. And that's what, that's what really gets me when you get into discussion on this, is how people put the facts aside and let emotions render their comments on these matters. Because when the research was actually done, there's only one Canadian jurisdiction, one, not a majority, one that actually posted on the public website. That's Ontario. And how long have they been doing it? The change was made this year, 2010. Do the regulations show us what specific information will be available on this public website? No. Does it tell us which specific form? No. None of that is there. To only one jurisdiction. So when the Deputy Premier said we'll be the first in Atlantic Canada, he could have said we'll only be the second one in Canada. And yet we don't know what the Ontario experience has been or what concerns have come out of that. But it gets better than that, Mr. Speaker, because one would ask, if you had a privacy concern, like any Nova Scotian might have, who do members turn to? Right now, under the legislation, the Freedom of Information, Protection of Privacy Officer in Nova Scotia is prevented from having any sort of authority over the conflict of interest legislation. So you can't call her. You can't call Dulcie McCollum. She has no jurisdiction. Specifically under the FOIPOP Act, she is not permitted to be involved with the conflict of interest bill. So then who do you call if you can't call her? Almost every other Nova Scotian has protection of their privacy and someone to appeal to, but not apparently once you walk into this chamber under the changes being proposed by the government. Again, I think this is changes that the government believes that will convince Nova Scotians that there's been a great change and that corruption that was taking place will come to an end. And that's unfortunate because that's just feeding into a mentality which I believe a minority of Nova Scotians, a small minority, still continue to have. I remember growing up, Mr. Speaker, I talked before of my days at Debate Shed and hearing people say, oh, well, the politicians are only there to fill in their pockets. And I would challenge them on that statement and say, explain that to me. How did they do that? Oh, well, they're in it for themselves. Okay, explain that to me. How did they do that? And no one was ever able to give me an answer to those questions. But it was just something, if you repeat it often enough, it almost sounds like it's true. And yet, this government seems to have bought right into that mentality, that the people that you elect can't be trusted. We go and we stand in front of them and ask for their votes that they can trust us and that we can represent them, but the government turns around and says, don't trust us once we walk into this chamber. That's basically the message. We did have conflict of interest legislation. Many of the things the Deputy Premier spoke about are already in practice. It is being done. The press has access to our disclosure statements. They're available at the Legislative Library. Any Nova Scotian who would want it, it is available through the Legislative Library. But is it appropriate to have this type of personal information being posted on a public website for anyone to use and manipulate as they wish? I think that's a discussion that we should have. And the argument of, well, everyone else is doing it, when we know it's not true, is just not good enough. And we shouldn't be submitting ourselves to that type of mentality. Now, here's the real challenge for us on the opposition benches. Regardless of what legitimate concerns we have with this bill, we're really at the mercy of the government and of the Deputy Premier to listen to our concerns. Because he can turn around and not make one change to this bill, and he knows we can't vote against it. Because if we stand in our place and vote against changes to the Conflict of Interest Act, we already know what the Deputy Premier will say the minute he walks out of this chamber. So we have no choice. We really don't. And that's what happens under majority government. And that's what happens with this piece of legislation. No one in this chamber is going to stand in their place and say no when it comes to voting on this bill. The member for Halifax Sable Island knows that. As much as in theory we can stand in our place and vote against it, he knows nobody will. Because that's exactly the message that will come from the government. So we are really at the mercy of the government to take their time with this act and make sure that members are comfortable with the changes being made and that the proper research has been done. But I would submit to you, Mr. Speaker, that the government's determined to have this bill passed during this sitting. And I don't see this sitting lasting that much longer, so the chances that we are going to get some of the changes that we've asked for, I'd have to say I'm not very optimistic. And that's unfortunate. Because what government, once this current administration will be replaced, what government is going to want to reopen the whole issue of conflict of interest? But my point would be, we should be taking our time with this to make sure we get it right the first time. We've gone through this before, Mr. Speaker. I recall under the government of Dr. Ham, there were changes brought in to the Members and Employees Disclosure Act, where new rules were put in, and it was strengthened at the time. And it was a debate that took place, and I think everyone agreed there was a need for those changes. But again, here is the question of how is that information going to be used? And I can tell you, Mr. Speaker, as a new parent, I don't feel the name of my daughter should be posted on a public website. And I don't think anyone else in this chamber should have any dependent children that they have posted on a public website. And that's what's being proposed here. Whether it's for safety, whether it's for privacy, I didn't put my name on the ballot to put them at risk. And that's what I believe this bill does. And again, I can't vote no on this. That's the reality. So either the government is going to look at the concerns we're raising and try to find a compromise here that addresses Nova Scotians' concerns. Because I can tell you, Mr. Speaker, and you know yourself, and I think the Deputy Premier knows, because we were both elected on the same time in 1998, and the voters in our ridings have shown confidence in us in 5 different occasions. And I don't have one person in Richmond County that's told me, I believe that the information about your wife and your daughter should be posted on a public website. I haven't had one in 13 years, and I don't think I ever will. So where's this demand coming from? And I don't think the Deputy Premier's had it either. I'm pretty sure the people at Cape Breton Centre have confidence in him and don't think that that's the type of information they expect him to be sharing on a public website that can be abused by anyone who wishes to do so. And as I said, Mr. Speaker, we learned during the MLA expense scandal that facts were irrelevant and that reputations were irrelevant because people could hide behind usernames and say whatever they wanted and got away with it. And they'll do it again. And that's what we're doing here, is feeding them and giving them that type of personal information, which no other profession would expect its employees or its directors to be posting on a public website. And I would suggest to you, it shouldn't be done for us here either. And when we look at the regulations, I would ask, well, is there anything there that will show that the concerns I'm raising, that that information will not be posted? The regulations are silent. They don't even talk about it. So there's no comfort there. Because many times when we raise concerns about bills, the government will tell us, well, the regulations will deal with that. Not this time. Not unless the regulations are going to be changed. And again, let's keep in mind, only one jurisdiction is doing this. And it's Ontario. And Mr. Speaker, when you look at the definition of dependent children, often we think a dependent child, it may be someone under the age of majority. Not necessarily. If they're still dependent and living at home for whatever reasons, that's going to be posted on a website. No Nova Scotian expects their elected members to have to share that type of information on a public website. What purpose would it serve? What conflict would a member be in having a dependent child who's 32 years old? And how is that going to give Nova Scotians better sense of confidence in the work that we do? But that's what's being proposed under this legislation. Mr. Speaker, there are other provisions as well which, as a lawyer, concern me greatly. And it feeds into a pattern that we've been seeing from this government when it comes to respect for the legislative chamber and respect for the elected body. We've seen that through the division or the dismantling of the Speaker's office from being an independent body of government to now being put under the control of the Department of Finance. We've seen the concerns raised by former Clerk Rod MacArthur, former Speaker Art Donohoe, who raised concerns about the fact that the legislature must remain independent. It must be above the arm of government. They are the duly elected members that Nova Scotians have sent, and they must be allowed to do their job. But provisions in this act, and I'm being told it may have been in other acts, regardless, it allows an appointed judge in Nova Scotia to remove a duly elected member of this chamber from office. Mr. Speaker, I would suggest to you that that completely violates the division of powers between the judicial, the executive, and the legislative branch of government. I have no issues if the government wishes to make changes to the House of Assembly Act to deal with matters where a member might be found to have violated the Conflict of Interest Act. Here in this chamber is where we should be dealing with those matters, where there can be an open debate and where the duly elected members of this legislature can impose the rules on our own members. No appointed judge should be able to remove a member from office when that member was duly elected in a free and democratic vote. But that is what will be permitted under this legislation. And Mr. Speaker, you'd be well aware, changes have been made to the House of Assembly Act over the years to deal with elected members who did get in trouble with the law. We now have, under the House of Assembly Act, that a member who's found guilty of indictable offense with a penalty of over 5 years can be removed from this chamber by the House of Assembly. But under this Conflict of Interest Act, we're prepared to allow an appointed judge to remove a member and declare a seat vacant. I would suggest to you, Mr. Speaker, that's unconstitutional. It is not how the British parliamentary system was established, and as such, those provisions should be removed from the bill. One of the other issues which I've raised after looking at the Act is the decisions made by the Conflict of Interest Commissioner. I believe that we should clearly state in Bill 99 that any decision of the Conflict of Interest Commissioner should be the same and put forward in the same fashion as a decision by the courts and by judges of this province. That being, it should refer to case law, it should refer to statute, it should refer to precedent, and it should make the logical argument of how all of those put together is how the decision was rendered. I would submit to you that right now, that is not a requirement, and decisions that have come down have basically been decisions based on a personal judgment of the Commissioner. Now, I have no doubt that the Commissioner has probably done research and has probably looked at case law, looked at previous decisions, everything else. Unfortunately, in a number of matters that I have read decisions, it's not in there. So it's very difficult, Mr. Speaker, when you have a decision, when you can't actually look at basically how it was determined, and a decision on the same matter that might have been made 5 years ago, what was the decision in that case? So I believe that that needs to be strengthened, that it needs to be made clear as well. My quick review of the legislation, to me, left doubt as to whether a decision by the Conflict of Interest Commissioner can actually be appealed to the courts. I was told that yes, it can, but again, I think those are matters that require further debate as to whether that is the case or not. But again, Mr. Speaker, I know our leader has pointed out, what impact will this have on future Nova Scotians seeking public office? Mr. Speaker, those who seek public office realize that there are certain amounts of private information that they're expected to disclose. But if we're telling Nova Scotians, if you run for public office, you need to have your spouse's name, your dependent children, your home address, your home phone number, all listed and posted on a public website, I would be curious how many Nova Scotians would want to stand office under those conditions. I can tell you as a young parent, I would have thought twice about entering this chamber had I known those were the types of rules. Not that I had anything to hide. As I told you, these changes have zero impact on me. I would suggest probably zero impact on most of the members here when I look around the chamber. Yet, that whole privacy aspect, I don't believe has been properly examined. I think it's a knee-jerk reaction, and I think it flies in the face of the confidence Nova Scotians have placed in us and the respect that I believe that most Nova Scotians still have for the men and women who serve in this chamber. Those, I would suggest to you, are the majority, and those are the people we should never forget here and not continue to focus on the small minority that regardless of what we do, it'll never be enough. Yet none of them will ever put their name on the ballot to run against us. We all know that. They'll criticize us, they'll say nothing good about our profession, but will never put their name forward. But we continue to put our names forward. And when I think back to the comment of when I was at debate shed, a fellow said, they're in it to fill their pockets. Mr. Speaker, I look around this chamber and there's no one filling their pockets in this chamber. There's no one getting rich in this chamber. In fact, I'm sure tonight as we go to the Speaker's reception, we'll often laugh and look and say, why are we doing this? That'll more be the question. Not discussions on our stock portfolios or on our investments, or what our investment advisor is saying as to what we should do. It'll be more, why are we doing this? That'll be the question. And I say that in jest, but you know, Mr. Speaker, that's the reality. But if we continue to play in that mentality that we're in it for the money, you know, Mr. Speaker, I can stand in my place and I can tell you, if you're to look at my colleagues who were called to the bar at the same time as I was, who are in private practice, they are earning over double what I am earning in this chamber. And I'm not saying that to ask for sympathy. I made a choice. I enjoy what I do. I don't regret my decision. I've enjoyed serving the people of Richmond County for 13 years. But it wasn't because it was a financially good decision on my part. and my colleagues who I graduated with are quick to remind me of how it was not a financially wise decision on my part. But that's why people enter this chamber. It's entering because it's a sense of wanting to serve. It's a sense of a sacrifice, of knowing that many aspects of your private life won't remain private anymore, but you're prepared to accept that. I believe this bill and the posting of that information on a public website crosses the line. And it crosses the line for members of the executive, it crosses the line for the government backbench, and it crosses the line for members on this side of the House. But if the Deputy Premier doesn't change it, or is not prepared to look at an amendment, I have no choice but to still vote for the bill. Because I would not be able to have the media or anyone who publishes commentary understand my concerns and why I would not have voted for this bill. And I'm sure the Deputy Premier will be the first to say how the Liberals and the member for Richmond are against strengthening the Conflict of Interest Act should we vote against it. So we're stuck. We have to vote for it. And yet, I believe what I've highlighted here are legitimate concerns. I believe when I look at the faces of the members of government that even they probably weren't aware of where exactly these changes are taking us when it comes to their own private information, when it comes to the security of their own families. I'm not sure that they even understood where exactly this bill would go. I have to agree with the leader of the Conservative Party that if we had put this either to a citizens panel or to a group of individuals in business and in other organizations that are familiar with codes of ethics and codes of conduct in the business workplace and the organization workplace, maybe we could have come up with some changes here that would enhance the bill and that would be very reasonable. But as it now stands, I can tell you, Mr. Speaker, I'm uncomfortable with the bill for the privacy issues that I've raised. Again, I can assure you I will not have to file an amended disclosure statement if this bill is passed. I do not have assets or liabilities that are going to have to be disclosed because the limit's been dropped from 25,000 to 10,000. And again, I would submit to you, I don't think there's too many people in this chamber that will have to either. But it sounds good when the Deputy Premier says it, and the media will probably play it up as being this wonderful thing that'll give Nova Scotians that much more confidence. Reality, it really does nothing. But it sounds good when you say it. But having information posted of a private nature is crossing a line. I think it sets up a dangerous situation, and the last thing we'd ever want to see is that any member of elected members' families be put in any harm because of the fact that they put their name on a ballot and because of an act that we pass here in this chamber. So I do hope that the Deputy Premier and that the Cabinet will want to look at changes and not want to rush through this bill, because while it may not have an impact on us today, it could certainly have a very negative impact and an unfortunate situation on the members that will follow us. With those remarks, Mr. Speaker, I do look forward to law amendments, and I certainly do hope that the government will be willing to continue the dialogue on both the Act and the regulations so that we can make sure that when we walk away, this is a matter that we will not have to be dealing with for a long time to come. Thank you, Mr. Speaker.
Thank you. The Honourable Member for Cape Breton North.
Yes, thank you very much, Mr. Speaker, and I'm pleased to rise with regards to the debate on the bill before the House at this time, and just to build on the comments rather than reiterate them that already have been made, and I'll try to be as brief as possible with this. But, Mr. Speaker, I do want to also share, and I know as you do, having been sitting in the chair of Speaker, and what information becomes privy to the Speaker, and what information is really appropriate for disclosure versus public dissemination, and disclosure for the purposes of transparency. And one of the things, Mr. Speaker, that I know, if we look back to a process, and sometimes that happens in haste, because when the Auditor General's report came forward with regards to the member's review, and that review, when it came forward, it's now called the MLA expense scandal. I know that when efforts went forward with regards to what was used to be the Internal Economy Board, and now with its new form, when that came forward, I remember sitting in as our representative in the Red Chamber And what happened was, for a process that was so severe in terms of public outrage and distrust and a negative perspective of what occurs here, I recall, Mr. Speaker, having sat in the Speaker's chair and dealt with the administration, never once while I was Speaker of this House did I actually assume that someone was doing something untoward or doing nothing less than what the financial provisions were in place for them to do. And we all know that with the regulations, if things were within that, they actually flowed through the Speaker's administration with the very hard-working people there. They were just merely following what was in place. And people's perspective, I remember where we got this issue of generators, became as a result of hurricanes and people wanting to help at a local level with regards to emergency response, whether it was seniors complexes, community issues, all of that stuff. I'm just saying the Minister of Community Services is snickering and shaking her head. I don't consider it a laughing matter. I'm saying there's a root cause, Minister, where this came from at the time. And what I'm saying is members, because they had an allocation, felt they would do that, and most, as the case may be, were done for sincere reasons at a community level. Now, the Minister was not in the House at that time, but I can tell you, many people independently, regardless of party, did what they felt was respective of the needs of their constituency, and that was urban to rural to semi-urban and rural. That's the dynamic we have. And I find it a bit disturbing that the Minister would want to snicker and dismiss this when I actually took it very seriously with regards to how things would come forward. I'm just trying to say about disclosure purposes, it was only when something was contravening that then it would come forward through the Chief Clerk and then brought to the Speaker to take a look at it. So sometimes people say, these things happen under your watch. Well, I would say is what is deliberate versus what is an unintended outcome. And people individually acting may have not taken in the severity of what the lens was from the public of how they would view those things. And that in one setting it may have been seen as a good thing, in another setting it may be seen as something that was inappropriate and not acceptable whatsoever. And so he moved to make changes. But Mr. Speaker, I was part of a process that came forward and sat in the Red Chamber willing to deal with then what became known as the members' expense scandal, and willing to sit down and be practical. But instead of wanting to have an all-party, full disclosure process, what ended up happening was there weren't even motions put on paper. There weren't even motions handwritten to disseminate. There were motions by the government member there, and I remember the Minister of Finance was there, and as they were doing it, he was saying, keep going, get these things through, we're going to clean this up. So it was, and the government, as of today, still pat themselves in the back as though they were cleaning something up rather than being part of a process that they themselves, as was accounted for by the Auditor General, where if you want to put blame, I guess, in the sense of disclosure, there was enough blame to go around because the Auditor General's report didn't have a political lens by party. It merely looked at what they thought should be appropriate process. So we went through that, and we had very hastily put forward measures by the government, which they went out and heralded as cleaning it up. And then I remember while we were there, it came up at the time, and a member from Cape Breton South moved the motion with regards to advertising expenses, because that seemed to be missing during that session, when indeed that was part of what the media were looking at in the variances. Aside from generators, a lot of extra money was spent on things like advertising. Again, in the individual areas and the settings, especially urban ones where there's so much going on, people communicate in different ways. We may be part of 3 parties in this House, but we are 52 individual MLAs that have to do their own operations because no 2 constituencies are alike. And that was part of what we had. So in response to the knee-jerk reaction that was coming from the government, the member from Cape Breton South then put forward the motion with regards to advertising, which was missed, of which the Progressive Conservative Caucus supported that, and the government, because they were before all the cameras of the day, then had to agree with it. And every member knows, did we have the best outcome that day? Have we truly reformed our constituency offices to the best and most transparent manner? And I would say, Mr. Speaker, we've made changes that were necessary, and we won't disagree with that. Has it made it easier for people to operate their constituencies? and heralding we took away all these expenses. Well, I can tell you, when the children and youth from the schools come in about Encounters with Canada, or the minor hockey group, or the young theatre players that are looking for some base resources from their representatives, I don't think as local representatives we've done them a good service. I don't think when we were providing those services we were doing anything untoward or illegitimate. But collectively, this House has tried to outcompete themselves as who is going to have the highest standard and raise the bar. And again, what I say that for is not to belittle anybody, but it just goes to show that the race to who is more right doesn't make a better or more rightful outcome. And we have not been transparent amongst ourselves. We have not, that to my knowledge, with this bill, talked amongst the caucuses. It was not presented in terms of what are the best forms. It was not provided for the full disclosure for debate. If we're truly sincere about it, these are important things. We have people with experience. Again, we have people from varying backgrounds, and all of that should be taken into account if we are truly trying to look at it. And as someone who may be moving on from this chamber, I look at it saying about the person that comes next. And regardless of who the people pick, is the next MLA, potentially for Cape Breton North, going to come into an environment that I can say is one where you can hold your head high, you're going to be able to serve your constituents. Because, Mr. Speaker, I truly, in my situation, try to represent and spend my money wisely, and I never was without accounting for that to the public. And quite frankly, and I admire the members that if there was an error or a mistake or a lack of judgment, they said it, they admitted it, they owned it, they went to the coffee shops and to their churches and community halls, and they dealt with it. And for those who could not deal with that, the public will judge, and for those that went and crossed the line, that is why there are other processes that are in place to deal with those things, and that's appropriate. But again, I relate this back to, have we truly helped people? We may have changed things for optics, but outcomes, and more importantly, representing your constituents. And if the future MLA for Cape Breton North is coming in, I'm going to say, can you more effectively represent your constituents? I would say, unfortunately, they're lacking some of the resources that they should have and what I think an elected official should do. And I'd really like, at some point, and hope that people can come back to some basis of normality and stop counting dollars and start talking about service to constituents and disclose all of that. I don't care about every cent that I spend in my constituency if people want to see it and if the community groups want to know it. But we in trying to deal with a problem have not really provided a solution, and that's where I'm going with this bill today. Have we really presented a solution by virtue of this bill? And because two of them go hand in hand to say, are we really serving Nova Scotians by trying to outcompete rather than do what this esteemed chamber should do, and that is to rise to the occasion of the challenge of the day as legislators, all 52 of us, and find the best consensus that is going to provide the confidence to the public that they deserve with disclosure, and at the same time provide us with the resources for the needs of meeting constituents' demands in this day and era. And we're in an era where, when I first started, didn't have a BlackBerry, didn't need laser printers, didn't have to have a computer work, but things shifted. In the 10 years now, close to, that I've been elected, the reality of what I started with in office versus what it is today is totally different. Yet we want to take a look and attack some of those things rather than say, are those the needs you have to represent people in a modern context? Because I know when I met with students, they want to know that I'm getting back to them through my Facebook site and they're signing up for Twitter. There's a whole new level. Rather than saying that's actually allowing you to communicate and work with people, someone's going to analyze and say, well, how much is it costing to do it? But society's changing, people are changing. The seniors clubs are getting in touch with us via their email and the internet, things that wouldn't have been a factor 10 years ago. So again, what are things relevant to this society? So I think we've missed the boat, and I do believe, Mr. Speaker, in haste, we had outcomes in that red chamber that we are all trying to find ways, the new forms of disclosure that will affect our advertising are going to come forward, and we're actually not serving our constituents in the manner we should be, in my humble opinion, that would be more effective for us. Because I've heard members, Mr. Speaker, grumble about what they can or can't do and what they could do before for legitimate community purposes, and that communities and constituents were expecting of MLAs to be able to do as a parliamentarian. And I've heard it from all members of the House, so there's no sense trying to say it's not the case. So what we have now, as a result of that process, that's how that's how the advertising thing was. The government rushed in things with no advance discussion. So the opposition put something in and forces the government to agree, and really has the public been better served? That's a real question. So now we have this bill, and there are some legitimate things that have been brought forward. And I would say, even with regards to disclosure of dependents, I know from having previously sat in that chair of a member, I will not name, that actually had a dependent, but it was actually a child of a dependent, but they were legally responsible for it. And it's no one's business if they're doing that because of family purposes, because the right thing to do. People do not need to know, in my opinion, if parents, in this case, that one being a member of this House, was taking care of grandchildren because of a reality that happens in life nowadays. Why would that be something someone would disclose? And that's what some of these things would result in. So why would those types of things, and I just sort of build on the member from Richmond, and when you talk about dependents, that's what we're talking about, because we do know, and everybody knows in every constituency, someone that's a grandparent that's taking care of a grandchild and helping out to take some pressure off, some stress because of life's realities. And really, is that the business of the people to know, and how does that relate to an MLA doing their work, if that's a potential outcome? So again, we talk about disclosure, but the forms of disclosure should be something we look at. And Mr. Speaker, if people want to know, if the Conflict of Interest Commissioner needs to know or would like to know what my personal financial situation is, to the member from Richmond, I don't have an issue with the Conflict of Interest Commissioner being provided that and holding that in trust as an officer of this House. If it's provided for the need, if issues of conflict come up, that it can go to the Commissioner, and that is fully disclosed to the Commissioner, so that person can make a proper assessment of any situations that come forward or questions that may arise. And Mr. Speaker, I think when we talk about what goes online, well, someone wants to know if I've got a mortgage. Well, yeah. And the other question is, what's anyone's business what the number is? But if the Commissioner wants to know it, just by virtue of, if you're in cabinet, someone's doing contracting work, I mean, it's happened elsewhere in the country, so people can verify it, they'll have it. That's for the Commissioner to verify. And I would say, one of the things we have to look at is, what would Nova Scotians want to know of their politicians and know about them in relation to their ability, or if they're fit enough to do their job, and if they are truly in conflict or not. And we've talked about forms of disclosure. So, Mr. Speaker, I would just echo the comments that have been raised and say that I think the government's desire for making sure there's better disclosure is something we all support. The form of that disclosure may not be the outcome we have, because we still are in a process where we have patchworked together and we've knee-jerk reaction to so many things in the race to be who's more right than doing what is right for us as legislators in this House, and making sure the public has full confidence that 52 members can stand up and say, I believe in the processes of this House. I agree with them. I accept them. I'm happy with the disclosure that's there. But what we have is something that is, again, unfortunately, that coming across as this is the government, as they've been doing, patting themselves in the back that they're more right than the opposition, but they may find themselves another day with another government determining how right they were. Thank you, Mr. Speaker.
Thank you. And thank all members. If I recognize the Minister, it will be to close debate. The Honourable Deputy Premier.
Thank you, Mr. Speaker. Mr. Speaker, may I say that I truly thank all the interveners here today. I've heard what they said. In all sincerity, we will look at if we can improve this bill with those interventions, we will. But with that, Mr. Speaker, I close debate on Bill number 99.
The motion before the House is for second reading of Bill number 99. Are you ready for the question? All those in favour? Against? The motion is carried.
Bill number 99, an act to avoid conflict of interest by members of the House of Assembly, members of the Executive Council, and public employees.
Order that this bill be sent to the Committee on Law Amendments. The Honourable the Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, could you please call Bill 100, the Labour Board Act?
Bill 100, the Labour Board Act. The Honourable the Minister of Labour and Workforce Development.
Thank you, Mr. Speaker. I am rising to move second reading of Bill 100, the Labour Board Act. Our government introduced the Labour Board Act on November the 19th because we believe it will improve the labour relations climate in this province. We know that the men and women of Nova Scotia want to be actively engaged in the work they do, and we understand that employers and employees want to share a professional and productive working relationship with one another. Currently, Mr. Speaker, labour relations in Nova Scotia is governed by several pieces of legislation. In the past, legislative changes were made in a piecemeal fashion, addressing issues as they arose. And some labour relations legislation has not had a complete review in some time. For example, it has been 25 years since the last comprehensive review of the Trade Union Act. Mr. Speaker, we are taking a strategic approach to correct the shortcomings of earlier administrations. Our first measure is the formation of a Labour Management Review Committee. And the committee's scope includes all labour relations issues and relevant legislation, including the Civil Service Collective Bargaining Act, the Highway Workers Act, and the Corrections Act. The committee would review labour relations legislation and recommend possible future amendments. It would also advise government on labour relations issues. Mr. Speaker, we would establish this committee in the coming months to ensure a timely review of the Trade Union Act. It would have up to 10 members with labour and management equally represented. Key business and organized labour leaders will be asked to nominate representatives to the committee. We believe the Labour Management Review Committee will provide an informed approach to keeping our legislation current and responsive to the needs of the labour relations community. In addition to the input that the Labour Management Review Committee would provide, we are also streamlining the dispute resolution mechanisms currently in place. Mr. Speaker, for many years—
Order, please. The chatter is getting quite high and it's hard to hear the Minister. The Honourable Minister of Labour and Workforce Development has the floor.
Thank you, Mr. Speaker. For many years, we have maintained 4 boards to address labour relations issues in this province. And the majority of disputes are currently heard by the labour relations boards. In an average year, the Labour Relations Board holds about 150 hearings. And there are 3 other boards established under separate legislation, and each dealing with specific groups of employers, employees, and issues. Mr. Speaker, I'm referring to the Civil Service Employee Relations Board under the Civil Service Collective Bargaining Act, which hears disputes between the province and the union that represents civil servants. Similarly, Mr. Speaker, we have the Highway Workers Employee Relations Board under the Highway Workers Act for disputes between the Department of Transportation and Infrastructure Renewal and the union that represents highway workers. Last but not least, Mr. Speaker, we have the Correctional Facilities Employee Relations Board under the Corrections Act, which addresses disputes between the Department of Justice and the union that represents the men and women who work in our jails and prisons. Mr. Speaker, I mentioned earlier that the Labour Relations Board hears about 150 cases per year. The other 3 boards are used less frequently. For example, the Highway Workers Employee Relations Board has held 3 hearings in 13 years and arbitrated 10 disputes. Mr. Speaker, this bill would merge the Labour Relations Board, the Civil Service Employee Relations Board, the Highway Workers Employee Relations Board, and the Correctional Facilities Employee Relations Board into one new board, the Labour Board, in early 2011. Across the 4 existing boards, one constant remains. Each board deals with contract disputes between employers and unionized workers. And we believe that it would be more efficient to have one board hear all these disputes. The Labour Board Act would streamline our processes, allow the Labour Board to operate more efficiently, and ensure that its resources are used to full capacity. That is the process in most other Canadian provinces. Mr. Speaker, the legislation will establish a regime where disputes will be resolved with more consistency and greater clarity for our clients. The new Labour Board would have a full-time chair appointed for a 5-year term through an order in council. The chair's compensation would be comparable to a deputy minister's, currently in the range of $137,600 to $189,200. We will build on the shared expertise of these boards and make better use of their resources. This will avoid duplication of effort and deliver improved supports to the labour relations community. And Mr. Speaker, we have a transition plan to minimize inconvenience or confusion for clients during the merger. Existing board members would move to the Labour Board until their current term ends. At that point, they could apply for reappointment to the Labour Board. The new full-time board chair will take the lead in developing processes and approaches to decisions, leading to greater consistency for clients. At the bill briefing on Friday, Mr. Speaker, I received a few questions around cost savings, the number of board members, and similar topics. For the benefit of those here this evening and those listening, I would like to explore these areas in a little more depth. The 6 existing boards have about 55 arbitrators. These people are not on staff, they are on call, if you will. They are appointed to arbitration boards as caseloads require. The new board would maintain a similar number of arbitrators, and again, they would only be paid when they are arbitrating a dispute. And for clarification, it is the employer and the union that share these costs, not the taxpayer. There are no plans at this time to reduce administrative support for the boards, only to use those resources more efficiently. So, Mr. Speaker, the Labour Board will be more efficient in terms of how fast hearings are scheduled and in the consistency of decisions, but the overall operational costs will remain approximately the same. We may see lower operating costs over the long term, but that is not one of the key drivers to the approach that we are taking. Mr. Speaker, as I've explained, the current labour relations system is confusing for stakeholders. With 4 boards in place, some people do not know which board would hear their dispute. The situation is further complicated by the existence of 2 more boards, the Labour Standards Tribunal and the Occupational Health and Safety Appeals Board. These boards do not address labour relations disputes, Mr. Speaker. The Occupational Health and Safety Appeal Panel deals with workplace safety issues, including administrative penalty appeals, while the Labour Standards Tribunal handles disputes about workplace standards, minimum wage, hours of work, terminations, and the like. I mentioned earlier that we intend to merge the 4 labour relations boards in early 2011. A few months after that, Mr. Speaker, the Labour Standards Tribunal and the Occupational Health and Safety Appeal Panel would join the Labour Board. This bill also introduces a number of operational changes that streamline our various processes and make them consistent across the board, if you will. Under the Labour Standards Code, there is currently no requirement for an employer to post a security deposit if they appeal a decision of the Labour Standards Tribunal. Mr. Speaker, this legislation would require employers to post a deposit to secure funds for payment and to reduce frivolous appeals. Similar practices are in use in other jurisdictions. The amount of the deposit would be set by regulation, but would not exceed the amount of the order that was being appealed. This legislation also proposes that the director be given authority by regulation to recover the cost of services provided under the code. This would occur in very limited circumstances. A specific example would be clearance certificates. When someone is buying a business, they often ask the department if there are outstanding charges or penalties that the business could be liable for. And we do a search of our records and provide a list. We don't feel that taxpayers should be subsidizing business owners who are making a business decision. That is the cost of doing business. This type of cost recovery would not limit employees and employers fair and reasonable access to justice. Overall, Mr. Speaker, the Labour Board will strive to be more innovative and to make greater use of technology, such as video conferencing, to reduce travel costs and time, both for panel members and parties appearing before it. The bill would also allow the board to issue some decisions based on written submissions. We know that on the whole, our stakeholders like tripartite boards, where Labour, management, and a neutral chair together create a balanced decision. But in some situations, workplace parties will have the option of using written submissions alone, without hearings, if they choose to do so. Simply put, Mr. Speaker, the new Labour Board will be more efficient, more transparent, and more consistent. We have proposed some other changes that will make our labour relations processes more efficient. Hearings about labour standards issues will no longer be recorded. The process is expensive and time-consuming, and we have not had many requests for transcripts. In the past, Mr. Speaker, justice lawyers have had to attend all labour standards hearings. Now, with a full-time chair in place, the Labour Board will have consistent processes, eliminating the need for a justice lawyer to attend to ensure that proper procedures were followed. Lastly, at the request of the Nova Scotia Construction Labour Relations Association, this bill includes a provision for the association to collect fees from its employer members, a framework to make dues payable and to ensure that appropriate safeguards are in place. Mr. Speaker, consequential amendments will be made to the Trade Union Act, the Civil Service Collective Bargaining Act, the Highway Workers Collective Bargaining Act, the Corrections Act, Schedule A, the Teachers Collective Bargaining Act, the Education Act, the Labour Standards Code, the Occupational Health and Safety Act, and to related regulations under these acts. Mr. Speaker, the labour relations climate in Nova Scotia has been relatively stable, with very few strikes or lockouts. Still, there are workplaces where unionized workers cannot strike or be locked out by their employer. For example, the public service, police, and fire service. In those instances, if the collective bargaining process fails, the parties make their case before an arbitrator, and the arbitrator decides what will be or not be in their new collective agreement. In some collective agreements, Mr. Speaker, there are lists of employment terms and conditions that can be resolved by an arbitrator. These lists tend to focus on monetary issues such as wages and salaries, overtime pay, etc., or other issues such as vacations and holidays, grievance procedures, and layoff policies. While the process seems straightforward at first glance, Mr. Speaker, there have been disputes over whether a specific condition of employment could be arbitrated or not. There have been cases where a dispute had to go before the courts to confirm whether an issue could be arbitrated. Under these proposed amendments, for workplaces where strikes and lockouts are not allowed, the list of terms and conditions that limits what can be considered under binding arbitration would be eliminated. This would prevent disputes about what terms and conditions can be arbitrated, and this should speed up the resolution process. Mr. Speaker, I've outlined several ways in which this bill would improve labour relations in this province. But like the infomercials say, wait, there's more. Mr. Speaker, there is a long-standing process in the way government addresses changes in the ownership of its services. In labour relations speak, these are called successor rights. Under successor rights, if a business changes ownership, the union that represented the workers before the transfer would continue to do so afterwards, and the collective agreement that was in place would still apply. For example, when the Property Valuation Services Corporation left Service Nova Scotia Municipal Relations to become a not-for-profit entity, the NSGEU continued to be their bargaining agent. The Property Valuation Services Corporation continued to be bound by the collective agreement that was in place. The process changes a bit when there are multiple unions and more than one collective agreement, Mr. Speaker, but the concept of the continuation of bargaining rights is the heart and soul of successor rights. Mr. Speaker, while successor rights have existed in practice, they have not been included in legislation as it pertains to the broader public service, and we are correcting that with this bill. Successor rights are common in the private and near public sector, and the Premier committed to make them a standard government policy and procedure. Wrapping up, Mr. Speaker, merging 6 boards into one will mean greater efficiency, greater clarity, and better transparency for employers, employees, and their unions. Eliminating arbitral lists will make it easier to resolve disputes for workplaces that cannot strike. Adding successor rights to our legislation will enshrine a long-standing practice that protects government workers. And the other changes we are making through this bill will, we believe, make for a fairer and more equal labour relations environment. Thank you, Mr. Speaker. I look forward to the comments from the honourable members on both sides of this House. Thank you.
Thank you. The chair now recognizes the honourable member for Bedford Birch Cove.
Thank you, Mr. Speaker. My remarks today will be brief. In her remarks at the bill briefing the other day, the minister said that merging 6 boards into one will mean greater efficiency. And we do accept that it may make the process more streamlined, but we have no evidence that it will mean any efficiency in terms of savings. And for a government that keeps reiterating that cuts are necessary, and we are talking major cuts coming up to some key government departments, we are surprised that we are talking about hiring a new person at a deputy minister's salary. And so we have concerns about that. Is this actually the right time to be adding a position with a salary equivalent to a deputy minister? This new Labour board could in fact have up to 54 members, and anyone who has been on any kind of a decision-making body that has 50 members or even more than 30 knows that making decisions that way is often very difficult. And well, as the member for Dartmouth East just suggested, it's sort of like council on steroids, and so it may be difficult to come to any conclusions there. allowing the government workers to continue to be represented by a union if their work moves to a private company. We're just wondering, is this anticipated at this time that we were going to see the government moving in this direction more? Is that why this has been included? This bill may have the effect of simplifying processes for workers and make things a little clear about where you're supposed to go when you have a certain problem. They'll now go to one board rather than trying to negotiate through different boards. But we need to make sure that we are responsive to the needs of workers on an ongoing basis. And with I do have to say that in terms of representations on this particular bill, I had not actually received any correspondence from any union or any party who would have been involved in that until this week. So I'm not sure that for most organizations it was a burning issue. And you know, here is another case where we are dealing with a bill that might be termed some housekeeping, when in fact we have not had formal responses from the government on some of the key issues of the day. We've had no formal response on the O'Neill report. We've had no formal response on the Ross report. And people are starting to term this session the Seinfeld session because it's a session about nothing. And we are wondering when we are actually going to get responses from the government on the big questions that are facing this government of the day. Thank you.
Thank you. Chair now recognizes the honourable member for Victoria the Lakes.
Thank you, Mr. Speaker. Mr. Speaker, I'm pleased to rise in my place to speak to Bill 100. Although Bill 100 will streamline some things and cut out some red tape, there's still many unanswered questions that must be addressed. Mr. Speaker, Bill 100 consolidates 6 boards in the labour field, including the Labour Relations Board, which deals with labour relations in connection with unionised employer, and the Labour Standards Tribunal, which deals with non-union situations. It should be noted that a majority of the provinces have already brought in and passed similar legislation. Only Nova Scotia, PEI, and British Columbia have so far not done so. Mr. Speaker, the new board will have a large number of members who will be retained until terms end and will then be eligible to reapply, about 54 members. One of the real concerns might revolve around who becomes full-time chair of the new Labour Board. Normally, in the past, a panel hearing the case will consist of a Labour representative, an employer's representative, and a neutral chair. There are reasons for this, including it's useful to have panel members who understand the specific matter at hand. If it's a highway matter, there'll be reps who understand how highway construction works, similar if it was another construction problem, and so on. The neutral chair would likely also be a person with some familiarity with the subject matter. Mr. Speaker, there's concern in the legal and employers community about who will be the chair, and they're concerned that it might be someone biased towards one side of an issue. Historically, professors or retired professors from Dalhousie Law School or a retired deputy minister with a legal background have headed boards in this area of activity. But to take a job full-time, as Bill 100 proposes, such an individual would have to give up his or her law school job and thus lose seniority and possibly long-range employment, although the salary of $187,000 ought to somewhat alleviate that burden. Mr. Speaker, in New Brunswick, a similar consolidation into a single Labour board occurred under the former Graham government, and a very union-friendly lawyer was appointed full-time chair, something which greatly annoyed employers. So, Mr. Speaker, some of the questions that must be asked are, how is this new arrangement going to benefit Nova Scotia businesses and workers? Another question is, why is it necessary to have a board of 50-plus people? Good point. Is the board going to continue to be made up of more than 50 people? Isn't this somewhat unmanageable? What about staff? Is there not a danger of the development of a whole new bureaucracy here? Can the minister ensure us that the chair and vice chair will be individuals who are both known for their integrity and impartiality in terms of labour relations? That is, they are not directly affiliated with or known supporters or advocates of either labour or management. That they are wise but neutral and fair individuals. With that, Mr. Speaker, these are some of the unanswered questions that are out there, and we look forward to hearing remarks as this bill moves forward to law amendments. Thank you, Mr. Speaker.
Thank you. If I recognize the minister, it will be to close debate. The Honourable, the Minister of Labour and Infrastructure, Workforce Development.
Thank you, Mr. Speaker. I want to thank the honourable members for their comments, and rather than repeat some of the content of my speech, I suggest you read it and answer it, and there will be some of the answers to your questions there. This is a significant piece of legislation, and I'm very pleased that a number of the labour leaders and business leaders in Nova Scotia were present at the bill briefing and certainly support the kind of consultation and development of this legislation that took place. So I rise now to close a second reading on Bill 100, the Labour Board Act, and look forward to it proceeding to law amendments. Thank you, Mr. Speaker.
Thank you. The question before the House is second reading of Bill 100, the Labour Board Act. Is the House ready for the question? All in favour? Against? The motion is carried.
Bill number 100, an act to establish a unified Labour Board.
Order this bill be sent to the Committee on Law Amendments. The Honourable, the Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, that concludes the government's business for today, and so I now hand it over to the leader, or the House Leader for the Progressive Conservative Party.
Thank you, the Honourable, the Leader of the House Leader of the Progressive Conservative Party.
Thank you very much, Mr. Speaker. Don't really want to be leader, so there you go. The hours tomorrow will be the regular time from 2 to 6. After the regular routine and question period, we'll be calling I believe Bill 80 and Bill 44. I think that's all I need to say. So again, we'll be sitting tomorrow from 2 to 6, and I now ask that the House do adjourn.
The motion before the House is that we rise now and meet again tomorrow between the hours of 2 and 6. Is the House ready for the question? All those in favour signify by saying aye. Against? The motion is carried. We shall now rise and meet together tomorrow at 2 p.m.